SJC-13737, Commonwealth versus Skipper Carino.
Okay, could you tell me how to pronounce your last name?
Chana.
Thank you, Attorney Chana.
Good morning, and may it please the court, Rachel Chana on behalf of the appellant, Mr. Carino. There are three ways that a 209A order to leave and stay an unspecified distance away from a residence can be violated. One, by entering the property on which the residence is located. Two, by taking actions nearby that directly intrude upon the identified property. Or three, being in a position sufficiently near the property that the defendant would be able to abuse or contact the plaintiff in the, yes.
We're going to jump to the third possibility, right? So,
Absolutely.
So suppose we look at the appeals court decision, the alternative ground they gave in the dissent by Justice Milkey. How do you get beyond the Lattimore standard? I see Exhibit 4 with the trees, and we're arguing about deciduous trees, apparently. But your person standing on the driveway, your client standing on the driveway in the adjoining street with the intent to do what he's going to do, admitted. How do you get beyond the Lattimore standard, applying the proximate manner to not stay away?
So as a factual matter, Mr. Carino was walking on the sidewalk, not walking up the driveway at the time.
He's at the foot of the driveway when they nabbed him, right?
The testimony was that he was somewhere on the sidewalk in the street, in that area.
Right,
correct.
apply the Lattimore standard.
Right. But applying the Lattimore standard, absolutely. The jury would have necessarily had to have piled inference upon inference to get there, to find that from where Carino actually stood, he could have abused or contacted the plaintiff in the event that she were on the property.
So intent is not required, but here they have intent.
Absolutely.
It's kind of a strange
Absolutely.
case.
So the Commonwealth's case was built entirely upon one, Carino's presence and his plan, right? And what his plan was cannot rescue the deficiencies in the Commonwealth's case as to what they failed to prove, as to the absence of evidence that they failed to marshal to show that from where he was placed, from his presence, what he could actually do from there, right? So what is the legal significance of his plan, of the plan that he had, right? So his post-arrest Mirandized statement, that went to another element that the Commonwealth was required to prove. One, Carino's knowledge of the APO and its requirement that he stay an unspecified distance away.
It also goes to, if he had the ability, say the trees weren't there, and he had the ability to peer into the backyard of the plaintiff, correct, the victim here, and the child was there or she was there, that would be a violation, correct, of a stay away?
It would be a violation on another basis because Carino was required to stay 100 yards away from the plaintiff wherever she was. And so had the plaintiff been on the property, we wouldn't be here.
Go back to the standard of proximate. So if he's in the adjoining yard, he has the ability to conduct his surveillance to see if she's home and the child happens to be there or he's peering in, he's in the position to abuse the person, whether or not he does so, correct?
Incorrect. That is not the standard. So when this third way was laid out by the appeals court in Watson in 2018, the Watson decision was explicit that O'Shea is still good law. And what O'Shea said, and the Watson court was explicit in saying this, that being in the vicinity is not enough.
If he can see her, she can see him. That's the thing I don't get.
Yeah, so the standard is that he positions himself proximate to the resident so that he'd be able to abuse or contact the plaintiff in the event the plaintiff were home, entering the home, or leaving the home. That's the standard, correct?
Correct. And
So if he's in the backyard, he's done that.
well, he's not in the backyard.
I know, but
and there
I want to
was no-
extend this. So if he's he's not in the backyard, but if he's on the driveway of the adjoining yard, and my hypothetical is there's no trees there, and there's a clear view of the backyard, correct? That would be a violation.
Maybe, but that's not this case. In this case, the Commonwealth elicited no testimony whatsoever as to what could be seen from the location where Carino was arrested. Carino was arrested by the police under the mistaken belief that the APO required him to remain 100 yards from the property, and the trial prosecutor essentially tried the case as if it were a straightforward distance violation.
So the only thing we have in this record, because there's no factual testimony on it, is that one photograph.
We have the aerial photograph submitted into evidence by the Commonwealth, and then Exhibit 4, the photograph taken to the left of the property in front of which Carino was arrested, that was admitted into evidence by the defense during cross-examination of one of the Commonwealth's 3 police witnesses.
What do you do with the fact that the very fact that he purposefully and admittedly walked up the street in parallel in order to observe whether she was home, isn't that circumstantial evidence that he knew and thought he could actually see into the house from the rear house?
No, Your Honor, because Your Honor is elaborating upon Mr. Carino's plan of what he planned to do, but the fact that he planned or hoped...
Am I? Because I thought he specifically told the police he walked up that street in order to see whether she was home, and if she was not home, he wasn't planning to truly, very clearly, unambiguously violate the order by walking up to the house and delivering a check.
That's correct. He was walking up a street parallel to the street on which the plaintiff's apartment building was, and he planned to walk down the driveway through the backyard, and however much farther he would have had to go, we don't know, because that evidence is not on the record.
So even under Lattimore, you're saying they basically arrested him too soon?
There's strong evidence that the police presence deterred a violation of the APO, but not that they detected a completed one. There was strong evidence that Carino had a plan to violate the APO, and he took steps in furtherance of that plan. That would have been an attempt crime, but he
still don't understand why he didn't violate it under the third way you can violate. If he is close enough to the property so as to be able to contact or abuse the victim, right? If the victim were present. It doesn't matter whether the victim's present or not. It's if the victim were present and the person, you're too close, right? No?
So this is I think the problem is the absence of proof of this. The Commonwealth simply didn't elicit any testimony or put forth any evidence of what Carino could have actually done.
He could have yelled. He could have yelled out and abused her verbally.
Maybe.
Well, that's what this
right.
This particular way of violating it speaks to.
And if the Commonwealth's theory is that a judicial order to stay an unspecified distance away from a property is violated whenever a defendant comes within what a jury may think is shouting distance, they had the affirmative burden of marshaling some evidence of that fact.
Isn't some of the evidence of that fact that this defendant, his statement, not because it goes to his intent to violate or attempt to violate the order, either one, but that the jury could infer from the fact of his plan and his execution of it that somebody positioned where the defendant determined to position himself because he clearly was familiar with where the victim lived could do what he had intended to do, which was try to contact or see into the victim's apartment.
Well, that wasn't what he had planned to do. What he had planned to do was deliver a check
But why was
to
he
the victim.
What was,
He didn't.
so just let me ask the question. What was his plan?
Mr. Carino's plan that he may or may not have executed had the police not deterred him.
What was his plan in going on Crescent Avenue?
He intended to approach the property from behind,
So-
trespass onto the property,
Trespass onto what property?
onto the property, the property on which the plaintiff's apartment building is located.
What was he doing on the backyard property?
He intended to approach the property through the yard of the abutting property and deliver a
So
check.
he intended to trespass on the abutting backyard property.
He intended to trespass on two
But
properties.
he also intended to conduct surveillance from that position to see if she was home or the child was home, correct?
Right.
That was part of the plan. So he had to position himself in such a way that he's in eyesight within the ability to abuse the victim were she at home. That's how you conduct surveillance. You have to be close enough to see.
Absolutely, but nowhere did the prosecutor argue that or elicit any information that Carino had actually gotten close enough to do that. And returning to your
Was there any
question,
testimony that he stopped as opposed to, was there any testimony that he stopped as opposed to he was moving in the direction? I haven't read this transcript. Yeah.
the testimony is that he was walking at the time that he was
moving.
arrested. He was walking on the sidewalk at the time he was arrested, and the police officer believed that he had come within 100 yards of the identified property and gave the order
What if
to
she-
arrest him.
What if she left the property and went around the corner? Would she have run into him?
Maybe if the Commonwealth had elicited testimony that there was some sort of easement or cut
No,
through such that she would have ever.
He's on a public street. He's on the parallel public street. She backs out of her car to go get a coffee. She backs out and rounds the corner. There he is, right?
No, I don't believe that is the evidence, Your Honor, from.
Well,
the
he's on
map
he's on Westminster, which is parallel to Crescent Hill.
Opposite, that he was on a street parallel to hers. And so not
Right.
only would she have to leave her home on her street, but she would have to like drive around several
Yes,
blocks
that's.
to go by him.
But he's proximate so that he would run into her where she leave the home, correct?
Maybe, but that would still require the piling of inference upon inference because proximity is simply not enough.
The third standard says, position himself proximate to the resident such that whether he's home or not, that in the event that the plaintiff will leave in the home, he's the next street over.
The government has some burden of making that argument to the jury and presenting some evidence of that other than his presence alone. Because again, O'Shea is still good law, and the facts of O'Shea are far worse than that.
Isn't this, but there, it's not like there was nothing. The jury did have a pretty clear picture of the two properties. And isn't that a classic thing for a jury to sort of, in using their common experience, to look at a picture of two houses back to back, and of someone, and there was testimony about exactly where the defendant was standing when he was arrested at the corner of the exhibit sticker, and they couldn't they in their common experience assess whether someone standing there with the other house right there, I'm referring to the Commonwealth's picture, whether that was close enough to abuse the victim?
No, not without
point it.
piling inference upon inference. The Commonwealth had some burden. If, for example, the Commonwealth's theory on appeal, raised for the first time on appeal, is that a stay-away order is violated whenever a defendant comes within shouting distance, they had some burden to show that Carino's voice could have traveled 200 feet, that ambient noise in the area wouldn't have muted sound, that the physical structures on the property wouldn't
They needed
have
expert
muted sound.
testimony?
Excuse me?
They would have needed expert testimony then?
No, I believe this could have easily been lay testimony by any of the 3 witnesses
But not-
who were there at the scene. That, for
People's
example,
common experience,
excuse me?
not in the jury's common experience. That's not something they could figure out.
No, not what the ambient noise would have been in like a densely populated residential area, not what physical structures, and not Carino's own individual voice, his vocal abilities or disabilities. He simply was not on notice because this evidence was not presented.
Okay, thank you.
Thank you very much.
Okay, Attorney Punch.
Good morning, and may it please the court. Assistant District Attorney Dylan Punch on behalf of Middlesex County for the Commonwealth.
Are you relying on the refrain from approaching a location standard in this case?
Yes, Your Honor, and that standard, as it was initially discussed in this court's decision in Gordon, and then in these 2018 cases, Telsonord, Goldman, and Watson is
Different from how it's articulated in Watson and Goldman. The appeals court in this case looked at the word stay and away and came up with a formulation that it requires you to refrain from approaching a location. Are you relying on that different standard here, or are you relying on what's articulated in Watson and Goldman?
I believe we're relying on both standards, Your Honor. Here, he was the standard that he was close enough to contact or abuse her if she was home, and he was required to stay away from the residence. And they really can
Okay,
be.
then let me ask you about this refrain from approaching a location. If a defendant lives in Boston and the person who has a restraining order lives in Provincetown, can the defendant be arrested when he goes over the Bourne Bridge?
No, Your Honor. As the appeals court articulated in Watson, these stay away provisions do have to be reasonably tethered to the property and the proximate area, and that's specifically what happened here. The proximate area.
You're still relying on the 3 Watson definitions of stay away. You're not relying on this more global one that the appeals court issued in this particular case.
Correct, Your Honor. I believe that
There's some definition, there's some reasonableness articulated in Watson that you agree with
yes, absolutely, Your Honor.
because of notice.
Because of notice, yes, Your Honor.
Otherwise, it'd be unconstitutional.
If there was no notice, yes, Your Honor. Now, here, the jury certainly had ample evidence that the defendant could have contacted the plaintiff. And here there was testimony that he was approximately 200 feet from her residence. They had the aerial map showing how those 2 residences are set up with the abutting backyards.
Contacted how? In other words, he could have clearly used a cell phone to contact the person, but I'm assuming the Commonwealth's not contending that would be enough to violate the order.
No, Your Honor. In this
Okay, so contact how? How do you think that abuse or contact in Watson, what do you think that means?
well, Your Honor, in this context, it means visual or vocal contact, and I believe that was in Telsonord. That was at 242, and they explicitly said that in 18. So here, if he could shout with his voice.
And reach the plaintiff if she were on the property or leaving it or entering it?
Yes, Your Honor.
Okay, so what evidence was there at trial of that?
Well, he was approximately 200 feet away.
And do you think it's a matter of common knowledge how far the human voice can travel?
Absolutely, Your Honor. This is
Okay,
two-thirds
so
of.
200 feet?
Yes, sir, that's-
Where relative to right now where I'm sitting on the bench, can my voice be heard 200 feet from here?
Absolutely, Your Honor. If you were shouting, it could. This is 2/3 of a football field. I mean, this is well within the common experience of a juror, how far, whether a voice could be heard or someone could see that far.
I would use Orchestra Hall for Justice Walhoden.
I think the acoustics are better in an orchestra.
There's one other point to this, though, because either for the Lattimore standard, which is the only picture we had at the time the Commonwealth rested, was the overhead, right?
I believe that the defense exhibit was introduced during the Commonwealth's case on cross-examination.
On cross-examination? Okay, so they have the 2 pictures. So both pictures show a lot of tree canopy. And the picture that was introduced by the defendant doesn't show a clear shot. And I don't disagree with you that, 2/3 of a football field might be okay for somebody to hear a voice. But when you look at the pictures, both pictures, either the overhead or the one that was introduced by the Commonwealth, you see nothing but trees from the vantage point of where the defendant was approached and apprehended and where the victim lived, or the person that was protected by the order. So again, not necessarily inference upon inference, but is it that clear that voices carry through all of that? Or that voices could carry through all of that?
I believe so, Your Honor, and respectfully, you can also see the victim's residence in the defense exhibit. You can see a window, you can see the siding of her house, the roofing, which does match the aerial photograph. And I certainly think the average juror would understand that a human being is capable of shouting 200 yards. If someone was standing in that...
But what's the ambient noise? Like to your football field analogy, I can yell 200 feet, but if it's a full stadium, I might not be able to be heard.
You may not be able to, Your Honor. And
So what is the evidence of the ambient noise in this neighborhood?
well, there may not be evidence of the ambient noise, but the jury was able to see from this aerial photograph the basic, how this neighborhood's laid out, how close the houses are. This is not a major cut through if you look at this photo and the reasonable inference. I believe that the jury would understand that their voice could travel. It seems like a classic reasonable inference that the jury could draw, Your Honor.
Sorry, could you just return to Exhibit 4? And I was really puzzled by the statement in your brief on page 19 that the photo introduced by the defendant clearly shows a line of sight from the top of the driveway to the back of the home, including windows at 187 Westminster Avenue. Could you, I don't know if you have it handy there, could you tell us where in the photo you can clearly see windows of the other house? Because I spent a really long time staring at the photo and I couldn't figure out what you meant by that.
Certainly, Your Honor. If you look, there's a white pickup truck parked in the driveway of the neighbor's house, directly touching the top left corner, because it's a 2D photograph, directly touching the top left corner, you can see the victim's residence. You can see the top left corner of a window frame. You can see her light-colored siding. You can see her light-colored roofing, which is visible in the aerial photograph. And further, in Justice Milkey's dissent, he
Are
himself...
you talking about behind the garage? I have it right here up on my screen, and I've enlarged it. I can't see any of that.
Yes, I'm sorry, the pickup truck?
There's a white pickup truck in the driveway. The top left corner of the pickup truck's roof is where the victim's residence is visible. And you can see
A bush and a tree.
there's a bush and a tree, and behind that, you can see the corner of the window frame. You can see the roofing and the siding, Your Honor.
Is this an issue that our copy of the photo is not as good as the original? Because in the copy we have, it is really...
It is, the copy I have is significantly larger than that, Your Honor, and it's clear to me. And Justice Milkey acknowledged that he could see it in his dissent.
Is that, that could be part of the record, correct?
Yes, Your Honor. In the record appendix, it's a bigger version.
No, it's in the RA, but the RA frankly doesn't do it for me. That can be provided to the court.
I believe it could, Your Honor.
It's going to be transposed from the...
And the version I have from the record appendix is where I was able to see it with my bare eyes, Your Honor.
Can I ask you, I just want to make sure I understand. I have it, and I can actually blow it up, but it's the house in the back, right? It's the one further over, right?
Correct. Directly behind it, Your Honor.
Right, okay.
So anyway, so you'll, Clerk Looney will get us that photograph from the clerk's office.
Yes, Your Honor. And this was available to the jury, and it really is just a matter of reasonable inference, whether or not they could see someone from that far, whether or not they could hear someone from that far. And that is the standard as it exists right now. Now, the defendant's behavior, it paints a full picture of exactly what the Chapter 209A is designed to prevent. He's positioning himself to monitor her comings and goings. And in Goldman, the court did mention that the flexible approach is intended to prevent someone from being encouraged to stand on the edge of a boundary and observe someone's comings and goings.
Right, but comings and goings how? Through the back of the property on which she lived, or through, it looked to me from the aerial photograph, coming and going is in the other street.
Yes, Your Honor, it looks like that, but the defendant here is familiar with this residence. He was there to see whether or not she was home, so presumably he wouldn't be there in that position if he was not able to determine whether she was home from where he was standing.
I think the problem with that argument, with all due respect, is that unless, and please correct me if I'm wrong, there wasn't evidence that this was where the defendant stationed himself. He was walking. He was still going when they stopped him. In other words, how can we make the inference? It's true that he said he wanted to go to look to see if she was home. How do we know that the point where the police stopped him is where he could do that?
Your Honor, we don't know exactly where he wanted to be, but we do know what.
Maybe he meant to go around the corner and look someplace where he could actually see whether she was there or coming or going.
Perhaps, Your Honor, and the question then becomes, could he have projected his voice? Could he have verbally or visually abused her were she on the property? And
right. So all I'm trying to say is that his intent doesn't shed too much light on that since he hadn't stopped. He was still in transit. And so what you have to have, I think, is proof that he could contact her either vocally or visually, I guess, be seen or see her from where the police happened to stop him, because there was no evidence that he himself had stopped himself there.
correct, Your Honor. And then we get back to, could he have shouted that distance from where he was standing? And I would posit that that is well within the
Matter of common knowledge.
So these photographs, are they of where he was arrested?
I don't know. So the defense exhibit, I'm not sure if that's exactly where he was standing. It was taken a month later. My understanding is the officer during cross-examination said it was a fair and accurate representation of the area, and we don't have much more than that.
So we don't know from these photographs where he was arrested?
We don't know where his footprints were exactly. Your Honor.
We know he was in the light most favorable. He was on the sidewalk approaching the driveway of that residence, of that driveway, that photograph that we have.
Yes, Your Honor. He was at the foot of that driveway.
What wasn't?
And they arrested him because they mistakenly thought the stay away was 100 yards.
Yes, Your Honor.
Does the defendant's intent matter here?
It does matter, Your Honor, because in this standard, mere vicinity is not enough alone. So if, say, he was going to someone's house across the street for a barbecue, but this was more than mere vicinity. It contextualizes what he was doing. I was here to watch her. I was here to figure out where she is, where she's coming and going. I know I shouldn't have been here. And as the Justice Desmond said in his opinion, it provides the jury a lens for which to view these circumstances, making these inferences all the more reasonable, what he could do and why he was there.
But that only works if he got to where he wanted to get.
Right.
Your Honor, he wanted to get to the mailbox. And now whether he was at the back to determine whether or not she was home, I believe that the fact that the residence is visual in the background, it's 200 feet, approximately 200 feet, which could mean less or more, but in the light most favorable to the Commonwealth, 200 feet could be 175 feet. And it's just whether or not he could project his voice that loud could he have contacted her if she was home or entering or leaving the property? If there are no further questions.